This is Barry Zalma speaking for Claims School Incorporated's Zalma's Insurance Fraud Letter, Volume 26, Issue 19 for October 1, 2022. This issue starts with an article about how an insurer became proactive against fraud and is working hard to deter further fraud. CIGNA Insurance obtained a $14,371,384.95 judgment against fraudulent health care providers. Since police, prosecutors, and state insurance fraud investigators are seldom willing to arrest or prosecute insurance fraud perpetrators, it is necessary for insurers to be proactive and sue those who attempt or succeed in defrauding insurers. In Connecticut General Life Insurance Company and CIGNA Health and Life Insurance Company versus Mike Ogbebor and Stafford Renal, LLC, a case in the United States District Court for the District of Connecticut on September 6, 2022, CIGNA successfully sued a fake provider and obtained a default judgment for almost $15 million against the corporate defendant and its alter ego. If you read the full issue of Zalma's Insurance Fraud Letter for October 1, 2022, you can read that entire article. Another Florida insurer has been declared insolvent. FedNat Insurance Company is now insolvent and must be liquidated. It is the sixth Florida property insurer this year to throw in the towel, and probably will, with the result of Hurricane Ivan, cause more problem for the people of Florida. The Florida Department of Financial Services filed a consent agreement with the Leon County Circuit Court detailing the extent of FedNat's financial troubles and asking the court to approve DFS as the receiver for the insurer. The move was not unexpected after FedNat agreed in May to cancel policies, transfer others to a sister company, and wind down operations with what regulators hoped would be an orderly runoff. You can read the full article if you download the PDF version of Zalma's Insurance Fraud Letter. The letter also reports about free insurance videos where more than 500 insurance videos can be seen at rumble.com. We report on good news from the Coalition Against Insurance Fraud with multiple reports of convictions of insurance fraud perpetrators, such as the one where, in shock and her blood pressure rising, Sharon Byton was stunned to learn that Bruce Saunders fell into a wood chipper and was ground up while clearing trees on her property near Brisbane, Australia. A tragic accident, it seemed. Prosecutors allege he was murdered. In a complex love quadrangle, Sharon Graham had two lovers, hit Saunders on the head with a crowbar, and place his lifeless body into the chipper so she could claim his $750,000 Australian dollar life policy. Graham is a former boyfriend of Saunders and was a policy beneficiary. You will also learn about a resource for the insurance professional, where I provide information on the excellence in claims handling programs that are available at my locals.com community and at my Substack publications. You can also find information and books written by me at Zalma's Insurance Claims Library, where you can learn about all of the books published through Amazon as paperback and Kindle books, and from the American Bar Association, Thomson Reuters, and Full Court Press. Then there's a listing of health insurance fraud convictions, noting that the U.S. Attorney and the federal investigators seem to have increased their efforts to prosecute fraud perpetrators, some of which include the durable medical equipment company healthcare fraud that was sentenced to 7 years in federal prison. Daniel Pintado Cazzola on September 9 was sentenced to 87 months in prison for his role in using a durable medical equipment company to commit Medicare and Medicaid fraud and trying to conceal his connection to the crime by listing a straw owner in corporate and bank records. Earlier this year, Pintado Cazzola pled guilty to 1 count of conspiracy to commit healthcare fraud, wire fraud, and mail fraud, and 1 ground and count of aggravated identity theft. You can read the full article in the PDF. Then there's the article about why prosecutors allowed an arson for profit to succeed by entering into a stupid plea bargain that destroyed the insurer's right to restitution. Intentionally burning a dwelling and the concomitant presentation of an insurance claim is an arson for profit and is 2 serious felonies, insurance fraud and arson. However, in People v. Damon Lawrence George, a California Court of Appeal decision from September 12, 2022, George was allowed by the prosecutors to plead guilty only to the unlawful burning of his house. The people, failing to understand the implications upon an insurer, allowed the insurance fraud to succeed by dismissing several related charges against the defendants, including insurance fraud, without obtaining a waiver of the holding of People v. Harvey, a California Supreme Court decision of 1979, and allowed the defendant to keep the money paid by the insurer. This full article is rather lengthy and interesting and is available on the PDF. Then there's a listing of other insurance fraud convictions. Those are convictions of other than health insurance fraud. For instance, a Salt of the Earth Michigan farmer was required to pay $1.2 million to the government as a settlement over his crop insurance fraud. Gaylord D. Lincoln and G. Lincoln Farms, LLC, located in Springport, Michigan, agreed to pay $1.2 million to resolve allegations that they violated the False Claims Act by causing the submission of fraudulent claims for federal crop insurance and federal farm benefit payments. The settlement amount was negotiated based on the defendant's ability to pay, rather than put him in jail for the amount he actually stole. This settlement resolves civil claims the United States brought against the defendants in a December 2021 lawsuit. In its complaint, the United States alleged that the defendants defrauded the U.S. Department of Agriculture Farm Service Agency by operating a scheme to avoid benefit program payment limitations. Specifically, the United States alleged that the defendants placed their farmland and crops in the names of their employees, who served as a facade for defendants but had no financial risk or interest in the crops and had them enrolled in Farm Service Agency benefit programs. These individuals then provided the FSA benefit payments to the defendants. The United States further alleged that defendants caused these individuals to take out fraudulent federal crop insurance policies for these crops, even though they had no insurable interest in the crops, and that the proceeds of the policies went to the defendants. The complaint and other filings in this case can be found in the court's online docket under United States v. Lincoln. You can read the full story about the crop insurance and FSA fraud at the PDF of the full Zalma's insurance fraud letter, along with other convictions. Then you can read about some new books from Barry Zalma, the latest of which is entitled How to Acquire, Understand, and Make a Successful Claim on a Commercial Property Policy. A new book called The Tort of Bad Faith, and an Insurance Fraudsters Deserve No Quarter book, all of which should help you in your work to defeat insurance fraud. This video was adapted from and is a shortened version of the October 1, 2022 issue of Zalma's Insurance Fraud Letter, number 19 in the 26th year of publication. If you found this video to be interesting and useful to you, please tell your friends and colleagues so that they can subscribe to Zalma's Insurance Fraud Letter, or by going to the link on my website where they can read the last 2 issues. Thank you for your attention.